very much, Professor Dr. Rahmat Mohamad, for your interesting presentation. Now I would like to invite Dr. Oveis Rezvanian, Director of the Tehran Regional Arbitration Centre. Dr. Rezvanian is an assistant professor of arbitration law in Iran and a member of the Court of Arbitration at the Arbitration Centre of Iran Chamber of Commerce. And also he's a member of the Swiss Arbitration Association and a member of the International Council for Commercial Arbitration. Dr. Rezvanian, please, you have the floor.
Thank you. Very good afternoon, ladies and gentlemen. I am delighted that Tehran Regional Arbitration Centre is hosting this very event, the gathering of AALCO Regional Arbitration Centres, and I hope other regional centers will join us in the rest of the ceremony, and I hope that these kind of meetings will continue in the next years. I also thank Professor Dr. Rahmat Mohamad for being a part of this ceremony and joining us for this event, and also my colleague in Lagos Regional, in Nairobi Regional Centre for Arbitration, Mr. Ngugi, for being here. And I'm very delighted that we gather this moment all together. In the next 15 minutes, if I may, I would introduce the structure of Tehran Regional Arbitration Centre as well as the purposes and the functions it might have. And also I will present the rules of arbitration that we use in Tehran Regional Arbitration Centre. In order to introduce TRAC, first I have to go back to AALCO. Professor Dr. Rahmat Mohamad had a very useful introduction as to AALCO. You know that AALCO was founded in 1956, and the headquarters is New Delhi, and so far 47 countries has joined AALCO. The main purpose of AALCO is to serve as an advisory body to its member states in the field of international law. In 1978, AALCO decided to establish some regional arbitration centers in its contracting member states. 5 centers so far have been established: Cairo, Kuala Lumpur, Lagos, Nairobi, and Tehran. Tehran Regional Arbitration Centre was established in 2004. Actually, it was established in 2004, but the agreement between the Islamic Republic of Iran and AALCO was signed in 1997. But it took a bit long time, around 7 years, to the agreement be ratified by legislative bodies in Iran. So eventually, after the agreement was ratified by the parliament in Iran, the AALCO established in 2004. So it is true that TRAC is the only international arbitration institution in Iran who is really independent and international, and it came into existence by an agreement which was ratified by the parliament, and eventually it became law. So we have the law of the establishment of Tehran Regional Arbitration Centre. Of course, TRAC is under the auspices of AALCO, and it works as an independent, neutral, international organization. When I say independent, I mean that TRAC does not have any affiliation to the government, and also the government is committed to respect the independence and impartiality of this center, and TRAC enjoys the necessary privileges and immunities provided for an international organization. The main purpose for establishing TRAC was to conduct domestic and international arbitrations, and also to promote international arbitration in the region, as well as to assist the existing arbitrations, either institutional or ad hoc arbitrations. And that is the main purpose of TRAC, and so far TRAC is endeavoring to accomplish these missions. You can see the model clause of TRAC, and I would like to take this opportunity and market it here among you to encourage you that insert TRAC model clause of arbitration in the contracts that you might have either in domestic or global level. You will see we have a standard clause, and if you just put it in your contract, all disputes arising out of your contract would be referred to Tehran Regional Arbitration Centre instead of being referred to a national court. This is how the arbitration works, and I am of the assumption that everybody here is quite familiar with the way that arbitration might work. So for being enjoyed by all services provided by TRAC, all you need to do is just to insert the TRAC rules of TRAC model clause of arbitration in the contract. Here is the structure of TRAC. I mean, we have the director at the top. The director is appointed by the Secretary General of AALCO with the consultation of the Iranian Center for International Legal Affairs. We have the representative of the center also here today, and we are delighted for that. And the director is responsible for administering all activities of the center with the assistance of the Secretariat, which is the assistant body of the director. So all the cases and all the institutional activities of the center is under the control of the director, which is the assistant of the secretary. We have also the arbitration board, that there are the members appointed by the director, again after the consultation with the Secretary General, and they are high qualified, very well-known, knowledgeable lawyers with experience in international arbitration, and majority from member states of the AALCO. So far, we have 3 members in our Board of Arbitration, and according to internal regulations of TRAC, the director shall consult with the arbitration board on all matters relating to the implementation of the rules of arbitration, and especially Articles 9, 10, and 11, which is regarding the appointment and challenging of the arbitrators. Dr. Mushtaba Kazzazi, Professor James Crawford, and Professor Jean-Jacques Arnaldes are right now the board members of arbitration in TRAC. We have also a very rich panel of arbitrators. They are from different countries, different jurisdictions. I invite you and I encourage you to visit our website to find out more about that. The roster of arbitrators, the panel of arbitrators in TRAC are composed of very well qualified arbitrators from different jurisdictions, different languages, and different expertise. In composition of the arbitrators and panel of arbitration, we are very cautious and careful to gather very knowledgeable lawyers who have different fields of expertise so that we can provide our users with more opportunities for selecting the arbitrators. As I will elaborate later, you will see that this panel of arbitration has just an consultory role, and it's not obligatory for the parties to select their arbitrators among this list, but it will be a great help to decide which arbitrator might suit best to their disputes. After introducing the structure of TRAC and the way it functions, it is time to introduce the rules of arbitration of TRAC. TRAC's rules of arbitration was published in 2005, I mean 1 year after the establishment of the center in Tehran. It essentially follows the ancestral rules of arbitration, but some certain aspects of the rules is being modified in order to customize it for institutional arbitration. You of course are aware that ancestral rules of arbitration are mostly drafted and mostly targeted for ad hoc arbitrations. So in order to customize it for institutional arbitration, some aspects of the ancestral rules of arbitration has been modified. If you ask me about one most salient feature and characteristic of the rules of arbitration of TRAC, I would say it provides the most possible freedom for the parties. So I would say TRAC rules of arbitration is one of the most flexible rules of arbitration, which has the least and minimum intervention by the center and leaves most of the issues to be decided by the parties. We are very flexible as to the agreement of parties and the issue of the parties' autonomy, and the intervention of the center is limited to the situations that the parties are not able to decide on the matter. In order to just give some examples, as to the place of arbitration, parties are free to decide about the place of arbitration, so they can have their place everywhere under the rules of TRAC. If the parties do not have any choice, the place of arbitration would be Tehran. We have also very strict rules of arbitration as to the confidentiality of the proceeding. This confidentiality does not only goes to the parties and their counsels, but also it is subject for the center, the arbitrators, the experts, the witnesses, the secretariats, parties, and their counsels. We never publish the arbitral awards without the permission of the parties, and even if we wipe out or eliminate the name of the parties, we are not allowed to publish it. So we are very cautious about the matter of confidentiality. The language of the arbitrations are subject to the agreement of the parties. Also, as to the appointment of the arbitrators, we are very flexible. The parties can decide on the procedure that they might wish for appointing the arbitrators. They can agree on the arbitrators. They can agree on the composition of the tribunal, whether it is a sole arbitrator or 3. But in any case and in any situation, if the parties are not able to decide about the composition or the arbitrator, the center will decide. I would like to highlight here an issue that it says that in Article 9.3 are rules of arbitration. It says that if parties fail to decide on an arbitrator or the arbitrators of the parties fail to decide the chair, the center will decide about the arbitrator. But in any event, the president shall be appointed from amongst nationals of a third country, that the arbitrator of the defaulting party shall not be appointed from amongst nationals of the country of the other party. This is quite an important issue. I just want to refer to the meeting that we had today in the morning with Swiss Chambers of Arbitration Institution. And I was referring to the rules of them that does not provide such basis. So it is, according to Swiss rules of arbitration, it is possible that you have a dispute and you from Iran have a dispute, for example, with a Swiss party, and the arbitrator is also from the same nationality, Swiss nationality. And this is a critical point that might cause some dangers for arbitration. Not only TRAC rules of arbitration, but also the law on international commercial arbitration in Iran, also from 1997, provides the same basis that the arbitrator of the defaulting party or the chair arbitrator, which is appointed by the center, should be from the nationality of another country other than the parties. Also, I would like to point out here Article 11 of the Law of International Commercial Arbitration, which might be a restriction as to the generally as to the arbitrations that might occur in Iran, which provides that before a dispute arises, the Iranian party may not undertake to submit the dispute to one or more arbitrators who are of the same nationality as the other party or parties. So this is not something related to TRAC. This is a general restriction that Iranian law on international commercial arbitration imposes on the party. So if you have a contract, you cannot in advance refer the dispute to an arbitrator which has the nationality of the other party. And you know that if the arbitration is going on in Iran, this law, we call it as LICA, the Law on International Commercial Arbitration, works as an umbrella law over all the international commercial arbitrations that might occur with the seat of arbitration in Iran. We have an extensive provision on the challenge of arbitrator. If each party wishes to challenge the arbitrator, he or she is free, it is free to do that, and the arbitrator would decide about the matter of the challenge. And if the party is not satisfied with the decision of the arbitrator, the center, the arbitration center will later decide which this decision is according to the law of Iran final and not subject to appeal. Rules of arbitration of TRAC provides a very efficient conduct of the proceeding. Unless any of the parties request for hearing, tribunal may decide the case solely on the basis of the documents submitted by the parties. And at the same time, we take very good care of the due process and equal treatment of the parties. TRAC rules of arbitration also provides for two doctrines of competence, and doctrine of separability, which means that, first of all, the arbitral tribunal has jurisdiction to rule on its own jurisdiction, and also the doctrine of separability is also accepted according to Iranian law and rules of arbitration of TRAC, which means that the arbitration agreement is separate from the contract that is underlying. So even if the arbitrator reached to the conclusion that the contract itself is not valid or is null or inoperative, it does not affect the validity of arbitration agreement. And if the parties have any challenge or any question as to the contract itself, this question also should be resolved and decided by the tribunal. How many time do I have? Sorry. 5 minutes? Okay, thank you. Thanks to Article 70 of Iran International Commercial Act 1997, TRAC is able to provide its user with interim measures of protection. So if a party wishes to obtain or acquire an interim measure, the tribunal has the jurisdiction, has the competence to render an interim award, interim measure of protection. As to the applicable law, there is no restriction for the parties to decide. They can decide about the applicable law to the contract, and this can be the applicable law, can be the Iranian law or any other law that might be agreed by the parties. So there is no pressure and disregard on the parties. And as to the costs of the arbitration, I would say cost of arbitration under TRAC rules is very competitive, and it is very attractive for the parties who might refer their disputes to this center. Cost includes the fee, administrative fees, arbitrators' fees, experts' fees, and any other fees that might be related to arbitration. And if we just compare the fees of TRAC with some other arbitration centers in the world, we would see that it is very competitive. On a general basis, and in principle, the cost of arbitration is borne by the losing party and unsuccessful party, but it will be decided eventually in the award. This was the basic elements of rules of arbitration of TRAC. As I mentioned before at the beginning about the activities of TRAC, TRAC is also active in the promotional and training activities, and we regularly organize workshops and seminars in schools and courses in regards to promote the international arbitration in the country and in the region. So the interested people, wishing people might join us for these events. Also, another initiative by TRAC, jointly by Arbitration Centre of Iran Chamber of Commerce, is that we launched the first Iranian Moot court for international arbitration in Iran, and we are intended to continue for the next years. I invite you to visit our website, www.trac.ir, for acquiring and obtaining more information on TRAC and activities. The website is very user-friendly. You can obtain news about the events, about the activities of TRAC over there. Also, you can find more information and useful information as to the arbitration in Iran over there. You can find the rules of arbitration and the model clause and some information about the functions and the structure of TRAC over there. Also, we have a subscription to mailing list, which you can subscribe and receive our news from over there. The website is also designed to be multilingual, so we have 4 languages. Apart from English, we have also Persian, Arabic, and French. So it makes it much more easier for the parties to get in contact with the website. If I may, I would conclude here. I once again thank you for your presence, and I thank you for your attention. Thank you.
Thank you for your presentation. Now we have the opportunity to get familiar with with the structure and the rules of another arbitration center under auspices of the AALCO, namely the Nairobi Centre for International Arbitration. And in this regard, we have with us Mr. Laurence Ngugi, who is the Registered Chief Executive of this center. He is also an arbitrator and accredited mediator member of the International Council of Commercial Arbitration, and he previously headed the Commercial and Arbitration Division Office of the Attorney General and Department of Justice in Kenya. Mr. Ngugi, please, you have the floor.
Thank you, Your Excellency, Professor Rahmat Mohamad, and the Director TRAC, Rezvanian. I am grateful to be part of this meeting today. I wish to express the gratitude of the Nairobi Centre for International Arbitration, especially to the Director of TRAC, for having made it possible for us to be here with the other centers. As I shall be covering later, you will see that Nairobi Centre for International Arbitration, as one of the centers under AALCO, is considerably the baby, being the most recently formed. And so we saw this as a good opportunity for us to interact with those who have been there before us, sharing their experiences and learn, given that we are modeled around the same principles and aspirations of AALCO. Now, in my presentation, just to have a quick glimpse of where we are located at. I have been to places where, when I say I'm from Kenya, Nairobi, and people ask me where it is. So I didn't want to assume that everyone would know where Nairobi and Kenya are. So we are located at the eastern side of the continent of Africa. As Professor did introduce, AALCO was intended to cover regional blocks. So Nairobi would cover the eastern and southern part of Africa. As he did mention also, there is Cairo, which covers the northern part of Africa, and there is Lagos, which covers the western part of the continent. So I am from about 7 hours away from Tehran in Nairobi, and that's where the center is located, in the capital city of Nairobi. As part of my presentation, the areas which I was asked to cover, to share with you, I will look at the establishment of this center. I will consider the principal functions of the center. Thirdly, I'll look at the governance structure. And fourthly, I will also look at the services. But before I get into them, I will just augment what Professor did mention. A series of meetings and resolutions have gone into place and work towards the establishment of a center in Nairobi. The last meeting of AALCO, it was reported advanced effort back home had been made to establish this center. And so, Professor, probably in the next meeting in May, confirmation will come from Nairobi that the center is actually now in place. So I will not repeat the history. The dates and the facts do not change. A memorandum of agreement was signed with the government of Kenya. And so with that, in the year 2013, when we developed what we call the Kenya Vision 2030, it was projected as one of the functions that government will enter into to ensure that a regional arbitration center was set up in Nairobi by the year 2017, which is next year. Around that same time also, in the year 2010, we overhauled our constitution, and within the constitution, in Article 159, alternative dispute resolution was made a constitutional principle, so that the judiciary in Kenya today is enjoined to ensure that it applies other forms of dispute resolution in all its processes. So we find an ally in the constitution in Kenya that supports dispute resolution as a basic principle of dispensing justice. In the year 2013, we enacted the Nairobi Centre for International Arbitration Act number 26, which introduced the center as an institution in Nairobi. I think from the previous presentation by the director, he did mention a long process of negotiation with legislators to eventually give birth to a center for arbitration. So that being the case, we now have the Nairobi Centre for International Arbitration, formed primarily, these are the principal functions. If you look at the functions of TRAC, many of these are replicated in that act, but I picked out the principal ones. The first one being promoting the use of international arbitration and other forms of dispute resolution. The second, it was also formed to be the lead agency in coordinating formulation of national policy, laws on dispute resolution. I could advert to a point made by Professor as he made his presentation. This center has been a focal point of influence in policy on dispute resolution, so this was one of the functions given to this center. Then also providing facilities, training, accreditation for dispute resolution providers, and I will return to this when I deal with the services. Fourthly, to undertake, promote, and act as a repository of research in arbitration and alternative dispute resolution. As we all know, there's a whole body of law governing international, especially international commercial arbitration. As Professor again did highlight, there are centers who have been there before, and have established a well-grounded body of law. So this center is placed to bring together research on these practices that think about the civil jurisdictions, the common law jurisdictions, Islamic law jurisdictions, and areas where we could gather information on practice of international arbitration generally and gather that body and become a repository of that research. So then, how does this center go about discharging those functions? Here I deal with the governance structure of the center. I have chosen to look at it from the perspective of a gear. We have three main institutions within Nairobi Centre for International Arbitration. We have a board of directors. We have an arbitral court. And also we have a secretariat. I'll describe each of these three in brief detail. The board of directors has a chairperson. It has two regional representatives. Now these two regional representatives are drawn from countries other than Kenya in the eastern part of the continent. Presently we do have an appointee from Rwanda, which is a neighboring country. Uganda. We did have a representative from Rwanda. However, he took up an appointment as president of the East Africa Court of Justice. So we are in the process of replacing a regional representative. And these positions were reserved by statute so that no Kenyan would be appointed to these two positions. Number three, we have three representatives from the public sector. This is now within Kenya. And number four, we have 5 representatives from the private sector. It might interest you to know that here we have a representative from the Kenya National Chamber of Commerce. We have a representative from the Kenya Private Sector Alliance. We have a representative from the Law Society of Kenya. And we have 2 representatives from the Chartered Institute of Arbitrators and its affiliate bodies. And then the registrar serves also as a secretary to the board of directors. So from this composition you can see, one, it respects the regional nature of the center, which means it introduces parties outside of Kenya. It also respects the fact that these centers are to be set up with no government influence. So you can see there's a heavy representation of the private sector. The chairperson also is drawn from the private sector. The 3 representatives from the public sector are mainly because it was given the mandate to influence policy and law on dispute resolution. So we have the Attorney General, a representative of the Attorney General, a representative of the Judiciary, and a representative of the Department of Justice, basically to be the channel that inbreeds policy on dispute resolution. When we come to the Arbitral Court, which I mentioned, we have a president of this court, not yet appointed. The structure is there, but the appointments are being worked on. A president, 2 deputy presidents, 15 eminent international practitioners as members of the court, and the registrar acting as a secretariat for this court. Now, in terms of the 15 persons, the eminent international practitioners, it is intended that this will be drawn from as far away as all the continents. And so, as I'll deal with the jurisdiction of this court, you can see again in the arbitral court, we have a representation both from the region and beyond this region. Why have an arbitral court? This court has been given jurisdiction to handle questions to do with challenge of arbitrators. There are issues of procedural questions that may arise during the arbitral process. It was felt one of the things that parties to arbitration, international arbitration, prefer is not to be subjected to domestic court processes. And so the court was established to guarantee parties who choose Nairobi as an option for international arbitration that whenever they have a challenge, procedural, appointment, rather than go to the courts in Kenya, there is already a court designed for them in the Act that shall be dealing with those procedural challenges. The decision of this court is final and binding on the parties, and it shall not be subject to appeal within the local jurisdiction in Kenya. Now remember, I did mention that the Constitution, Article 159, has made it mandatory for our own courts to respect dispute resolution. So we foresee if there is ever to be a challenge on this court, we already have a sister that supports us in the Constitution that respects dispute resolution generally. So other than the Arbitral Court, we have the Secretariat, which is headed by a registrar, a position which could be equivalent to director, the chief executive officer of the center, who then gives the Secretariat support to this tripartite structure that we have. And of course then we have the Secretariat staff who would include case counsel and the other similar staff in other centers. So then what sort of services are we to render? I say to render because, as I mentioned, we are the most recent of these centers. As it is, we already have benefited tremendously, especially from my brother, if he was here, from Kuala Lumpur, in addressing the question of our rules. We did constitute a team that evaluated the rules in the AALCO centers. We also did look at the ancestral rules, so our basic format is the ancestral format, again with modifications, as has been mentioned by the director here, to make it suitable for institute-administered arbitrations. Most of the features that which have already been mentioned by my colleague also will find in our arbitration rules. And maybe I haven't looked at your current rules, but one feature which he may not have mentioned, which will be found in ours, is a practice that has emerged recently in international arbitration, and that is emergency arbitrator. So there is a provision within our rules. For instance, if you have a requirement for interim relief, rather than run to a domestic court or any other court for that matter, our rules do provide that you can actually appoint an emergency arbitrator who will deal with questions of interim relief. And once you obtain that order, it's an order which will be enforceable in our courts and other jurisdictions which enforce emergency arbitrator orders. Besides that, independence of arbitrators, party autonomy, our rates in terms of fees and costs are highly competitive. We compare this with other centers, and so we are assuring parties that should they choose Nairobi as their preferred center for arbitration, they will find fairly competitive rates for their processes. The default seat of arbitration under our rules is Nairobi. However, if parties do select any other jurisdiction, they are free to do so. Many of these rules preserve Nairobi merely as a default, so that where parties do not nominate, do not appoint, then the center steps in as an institute to help progress the process of arbitration. Other than that, we have the mediation rules. This also came into force in December of last year. Again, largely respecting the principles of mediation, the independence of the parties, and the free choice and decision-making of the parties. The fee structure here also is very competitive. In both our rules, you'll find there is a separate